Assalamu alaikum. Okay, so what I'm going to be discussing over the next 10 minutes will be a high-level overview of three things. Number one, the Saudi Arabian arbitration law. Number two, the enforcement law, which is very relevant in the context of discussing dispute resolution generally, to understand how enforcement of judgments are going to work in the kingdom. And number three, the Saudi Arabian Center for Commercial Arbitrations rules in relation to arbitration. So those are the three topics that I'll be discussing over the next 10 minutes. There's been a clear trend in Saudi Arabia over the past few years in relation to enhancing the effectiveness of dispute resolution. It started in 2012 when Saudi Arabia passed the new arbitration law, which was itself based on the UNCITRAL set of rules. Now, what did that law have to say? Well, it provided for greater flexibility to the parties to settle their disputes in a way that they deem fit. It allowed a rather robust process for the dispute to go through the process of arbitration, and allowed the parties the ability to have varying different languages to settle their disputes. And that is an important thing for international investors to be comfortable with usually the language of the relevant contract, which in the corporate world is usually English. It also allowed the parties, as we just heard from the team, the ability to agree substantive law other than Saudi law, so long, of course, as the award does not contravene Sharia principles. One of the things that the law also allowed is for the parties to agree for injunctive relief, but also it limited Saudi Arabian court supervision, whereas the previous arbitration law required that a court approve the terms of reference, approve the arbitrators themselves, and the arbitration agreement. That is no longer required under the arbitration law. So that was topic number one, the arbitration law. Topic number two, the enforcement court. In 2013, a new enforcement law was issued, and the enforcement law set up the enforcement court in Saudi Arabia. Enforcement court in Saudi Arabia is in charge of doing two things: enforcing court judgments and enforcing arbitral awards, both local and international. And this was a great development for settling disputes in Saudi Arabia, and essentially very good development for arbitration, because now there is a clear mechanism through which awards can be enforced in the kingdom. One of the things that the enforcement law did was it defined an arbitral award as an enforcement instrument. And together with the arbitration law, we clarified the contents of that enforcement instrument and what it needs to include. It also empowered the enforcement court to do multiple things. For example, it allowed the enforcement court to investigate assets of the respondent or the defendant, to freeze assets, and to ask the police to intervene. And this is something that a lot of international investors sometimes are not sure about or have a mixed message about, the enforcement court does not open up the case on its merits. The enforcement court only looks at the prima facie requirements of the enforcement instrument, namely the arbitral award, makes sure that it meets those requirements and applies it. The only thing that the enforcement court should do is verify that the award does not contravene Sharia principles. And this is again something that international investors sometimes are confused about, because they think that if a case is to be enforced in the kingdom, then a court is going to open the matter up on its merits, and that is not correct. All right, that was item number two, the enforcement court. Let's move on to item number three, which is to discuss the Saudi Center for Commercial Arbitration's rules. I was a founding member of the board, and really thanks to the executive team at the time and today, these rules that I'm going to highlight have become a fantastic development for institutional arbitration. Now, one thing that we should all remember is that the center was not the first institutional form of arbitration in the kingdom. The Saudi Arabian Chambers of Commerce have an institution through which disputes can be settled. But what the rules did was created a robust and clear way to fix those gaps where if the parties do not agree on various issues, those rules would then apply. So let's go ahead and go through those very high-level set of rules. Well, the first thing is the rules are rather flexible. And as everybody here knows, arbitration is a creature of contract, and the dispute itself and the process through which it follows is also a creature of agreement between the parties of the dispute. And that's what the rules do. The rules allow the parties to agree the place of arbitration, the language of the arbitration, how information is exchanged between the different parties, how witnesses are going to be presented. We all know that arbitration lives and dies by the quality of the arbitrators. And if the arbitrators are not skilled or are not experts in the relevant matter that is the subject matter of the dispute, the arbitration will most likely not going to proceed in the most effective of ways, despite what rules are going to be applied. Every once in a while, parties to a dispute will also dispute the appointment of a chairman of a 3-panel tribunal or a single arbitrator in a single member tribunal. So what happens if that happens under the rules? Well, as Dr. Mustafa mentioned, well, there is the concept of strike and the listing and striking method. One of the things that the rules do, and this is something that as an arbitrator I certainly appreciate, is to clarify that an arbitrator is not going to be liable for any act or omission in relation to the case that they're arbitrating, and they cannot be called as a witness down the line in relation to the case that they are adjudicating. One of the things that the rules also do is that they give the power to the tribunal itself to interpret the rules insofar as it relates to their powers. And the center interprets the rules as it relates to their powers. One of the things that we have all seen as both litigants and arbitrators and as judges is that the concept of impartiality and independence is a very important concept, and I'm glad that the rules had affirmed it, and not only something that must happen at the beginning of a arbitration, but on a continuous basis. The rules further explain, and this is something that I'm sure some of you in the audience know about. A few months ago, a Saudi court voided an arbitration award. Why did that court do that? It did that because it discovered that there was ex parte communication between one of the members of an arbitration and one of the parties. As I'm sure you know, that is something that should not happen, and I'm glad that the rules have set that as a prohibited activity and gave the center the ability to remove an arbitrator that violates the rules. One of the things that happens in arbitration is a significant debate as to whether notice has been provided, what is notice, and where notice is sent. The rules go on to also explain that notice is basically any document that allows a record of a transmission of the information under which it was transmitted, and also defines that delivery can be deemed if it's delivered at any of the locations noted in the rules. This is something that I'm sure the litigators in this room here have suffered from time to time. Electronic notice is allowed. And one of the things that we were just actually debating just before we came into the stage here today is when arbitration actually starts. And the rules define arbitration to start at the moment that notice is delivered to the center. So what is a notice of arbitration? What does it include? What makes a notice of arbitration tick the box in relation to the commencement of arbitration? Well, the rules explain that it needs to include various pieces of information, such as the demand, the names of the claimants, identify the facts, and setting out essentially the basis of the claim, and of course the relevant contract. Now, who decides who decides whether a notice of arbitration is in fact sufficient? It's the tribunal. And this is actually a very important thing because it allows the arbitration to continue. The reply from the respondent needs to include some basic information, which includes, of course, a assertion of lack of jurisdiction and a counterclaim if one was defined within that. One of the things that I've researched under Saudi law is the concept of privilege, and I'm glad to see that the rules actually set out that communications between the parties and their counsel are protected and subject to privilege. And of course, as one would want arbitration to be, it is confidential, hearings are private, and the awards are confidential. Overall, the arbitration under the rules allow for an organized nature of the arbitration, including having a 15-day hard notice for hearings, for the tribunal to explain what the contents of the hearing is about, and allows witness lists to be exchanged between the parties before the hearing takes place. One of the things that respondents oftentimes do is essentially choose not to attend a hearing, and sometimes even claimants abandon a case after it starts. The rules explain that that is not sufficient for the arbitration to continue. Every once in a while, a tribunal would need access to subject matter experts. This happens in construction cases, as I'm sure the audience knows. And the rules allow that to be the case and require that, of course, they be independent, allow the parties to discuss and exchange information about who's going to be coming in, presenting, and allowing, of course, questioning of those experts. Finally, in terms of the award, as the enforcement law requires, the award must be in writing, must be issued within 60 days of the last hearing, and must be named as final and binding, and must be filed with the enforcement court. The obligation is on the tribunal to do so, and the parties must notify the tribunal of how and the process of that filing. As I mentioned before, in order for an award to be enforced in Saudi Arabia, it cannot contravene Sharia, but it can be subject to a law other than Saudi law. And the tribunal must, of course, apply the contract. To the extent that the contract is not clear, then the rules allow the usage of custom and practice. So, what I've discussed over the past 10 minutes was a brief overview of dispute resolution in the kingdom, how the arbitration law helped streamline arbitration in the kingdom generally and allowed the flexibility of institutional arbitration to spring up. We discussed the enforcement court and why that is an important development for the enforcement of court judgments and arbitral awards alike. And I took you through an overview of the Saudi Center rules. Thank you very much for listening, and I hope that we can engage in a good debate for the rest of the 2 days. Thank you.